Hi everyone, this is Jeff from Distress Loan Advisors, and in this short video we're going to discuss some common questions about SBA loan guarantees. You can find more about these topics and many others on our website, www.jasontees.com. Our first question is, if I file for personal bankruptcy, can the bank still legally come after my business and shut me down? The answer is yes. Assuming the business assets are owned by an entity other than you, such as an S Corp, a C Corp, or an LLC, the bank can still usually go after the business assets. This assumes that the bank required the aforementioned corporate entity to act as a borrower or guarantor, which is the case in 99.9% of the cases. Having your personal guarantee discharged only relieves you of personal liability. In other words, they can't go after your personal assets unless they were pledged prior to the bankruptcy, such as your home, bank accounts, or paycheck. Our next question. When I took this SBA loan, I was advised to form a corporation, which is listed as the borrower. Doesn't this shield me from personal liability? The answer to that is that forming a corporation certainly has some benefits. If the corporation was only an entity that was required to be named as the borrower or guarantor, you would be off the hook personally if the business became insolvent at some point in the future. Unfortunately, the bankers know this fact too, so in 99% of the cases, they require the business owners to pledge their personal guarantee in connection with the SBA debt. By doing this, you are essentially saying, fine, if the business can't afford to pay you, I will use my own personal resources that I owned outside my business to repay this loan. Some people tell us that they would never have gone through with a loan had they realized what the personal guarantee meant. First of all, shame on your banker and attorney for not explaining this to you. Second of all, we can assure you that had you refused to offer your personal guarantee, the bank would not have agreed to lend you the money in the first place. Our next question is, when I signed the personal guarantee, I thought I was signing as an officer of the company. Was I wrong? The answer to this is short. Yes, you were. If the document you signed says unlimited personal guarantee, you are personally liable. Another question we often hear is, does my business need to file for bankruptcy in order to qualify for a settlement? The answer is that no, in most cases just ceasing operations is sufficient. There may be other strategic reasons for filing a corporate bankruptcy, but doing it to qualify for an OIC is not one of them. Interestingly, the SBA has recently in certain cases begun considering reductions in loan balances on businesses that are still operating. It's still not the norm, but it's definitely a change from the past policy, which absolutely required a business to be closed. Folks often ask us, will the bank be able to foreclose on my home if I file for a personal Chapter 7 bankruptcy? This one depends. If there was a lien on your home prior to the bankruptcy, then the lien will not be extinguished. If there was not a lien prior to the bankruptcy, having your personal guarantee discharged will protect your home due to the fact that the bank would not be able to liquidate your personal assets in order to repay the SBA loan. Something else we often hear from folks is, I met with a bankruptcy attorney who recommended that I file for bankruptcy. Why should I try to settle the debt instead? We tell all prospective clients the same thing. You should gather all the facts, then make an informed decision. Whichever approach you take will have its own unique pros and cons. The key is to fully understand those pros and cons so that you don't regret your decision later. There's no one right approach. Your individual situation will often dictate which approach makes more sense. And our final question for this video is, the person at the bank told me that since I owe them so much, I should file for bankruptcy because the SBA will never release my personal guarantee. Is that correct? Whenever we hear this, it shocks us. Your banker, who works for the bank, not you, should not be offering legal advice of any kind. When Jason was a vice president in the workout department, he'd always tell borrowers that if they had legal or bankruptcy questions, they should speak with their attorney. Only an attorney should be recommending whether or not you file for bankruptcy in order to avoid an SBA loan personal guarantee. It's one thing to discuss the pros and cons of bankruptcy. It's quite another to say, the only way to get out of this is to file for bankruptcy. We hope you found this video informative and helpful. For more on these issues and many others, visit us on the web at www.jasontees.com. And for advice on your personal situation, don't hesitate to contact us. You'll see our information on the screen right now.